Good afternoon. This is Allison Pena with Worldwide ERC. Thanks to everyone for connecting, and welcome to today's webinar program, U.S. Immigration Law, Where Are We Now, and What's to Come, sponsored by TRC Global Mobility and presented by Envoy Global. Before we begin, please take a moment to review Worldwide ERC's webinar disclaimer. And now I would like to go over a few housekeeping announcements. If you are experiencing technical difficulties joining the WebEx session today, please dial 866-779-3239 from the U.S. Email questions may be sent to support@webex.com. During this presentation, all participants will be in a listen-only mode. If you have a question during the presentation, you may submit it online at any time. To submit your questions, please use the Q&A tab located in the lower right-hand portion of your screen. Simply click on the tab and type your question into the dialog box at the bottom of the screen and then click the send button. Please note that all written questions selected during this webinar will be answered publicly. We do expect a high volume of questions and will attempt to answer as many as possible. Lastly, a link to this handout and recording will be included in an email scheduled to go out later this afternoon. Please be on the lookout for it. It will come from messenger@webex.com. Today's webinar is eligible for 1 CRP and 1 GMS credit. If you hold your CRP designation and would like to receive credit for this webinar, you will need to use the CRP Credits Management Portal, which may be linked to from your profile page after logging into the Worldwide ERC website. The seminar ID for today's session is 15336. If you are a GMS seeking CE credit for this webinar, you must include the name and date of this webinar on your GMS renewal application at the time that you apply for recertification. The renewal application is available online. And now I would like to introduce today's speakers. Jamie Gilpin is a veteran to the HR technology industry, and she brings more than 15 years of sales, marketing, and branding experience to Envoy. As CMO, Jamie plays a key role in driving a powerful brand for Envoy that represents its dedication to providing education, support, unparalleled value, and a better experience for both businesses and employees navigating the immigration process. Prior to Envoy, Gilpin was the Vice President of Marketing at Career Builder, where she studied the relationships between job seekers and employers for more than a decade and became passionate about solving the skills gap. Jamie has spoken on the skills gap, workforce trends, big data, and technology at numerous industry conferences and in media interviews. Sarah Maxwell is a licensed attorney and the head of global immigration at Envoy. Her experience includes handling corporate and employment-based immigration law, particularly in developing and executing global immigration policies for Fortune 500 companies. She has counseled multinational corporations on the movement of personnel across the globe and facilitated the assignment of expatriates to the EMEA and APAC regions as well as the Americas. She has also provided training, functional direction, and insight to recruiters and hiring managers to help them transfer personnel at the global level. I am delighted to welcome Jamie and Sarah. Thank you for joining us. I will now turn the program over to Jamie.
Thank you so much, Allison, and hello, everyone. Thank you for joining. A couple more thank yous, and then I'll move on. But a big thank you to ERC for hosting, of course, TRC Relocation for sponsoring. Both of you are just truly great partners to our industry, and we're proud to work with you both. So thank you. And for those of you who don't know, Envoy, we are the technology leader in global immigration, and just excited to share knowledge on both sides of sort of the fence of our industry right now. Not only, and of course, the main spotlight of this webinar will be Sarah's expertise on the changing landscape of immigration policy and what employers should know. And then what I am ultimately going to start with is really our research that we've done on the immigration management side of things. And so I'm just trying to flip through on this next one to share the agenda. It doesn't look like I've got full control, but maybe Allison.
You do. It should be at the top. If you did a full screen,
okay.
You go. You got it.
There we go. Okay. Always fun technology, figuring things out on these webinars. But yeah, excited to dive in. So as Allison mentioned, I'm the CMO here at Envoy, but a big part of my job is actually research. So third-party research, talking to employers, customers, and prospects alike. We also partner with Harris Poll Nielsen to do a statistically significant survey once a year. We've done this for 3 years, so I'm going to share some of the trends that have really has been fascinating to watch over the last 3 years. So I'll share those, and then I will pass it over to Sarah, like I mentioned, to talk through what this all means in terms of policy and what you should remain not only just aware of, but also possible recommendations for how this applies to your organizations. So like I mentioned, we do quite a bit of research, but our big sort of pivotal piece that we put out once a year in February is this global immigration trends. And so about 400 survey respondents, half HR, half hiring managers. And again, what we try to uncover is trends that we're seeing in really managing this function for organizations. And so as someone who's passionate about the skills gap and has been studying this challenge for employers to not only find talent but retain it, it's not too surprising that this number has actually gone up quite a bit from last year. So 63% last year, but 70% of employers say that sourcing foreign national employees is very to extremely important to their talent acquisition strategy. Why? Well, because of all the things that all of us on this call are acutely aware of. They are a huge value add to our talent. They obviously bring new and valuable perspectives to the way we do business. Again, they fill our skills gap, especially in those STEM areas. International talent, or this wider talent pool beyond just the U.S., brings global competitiveness, knowledge of markets outside the U.S. So the list goes on. And so not too surprising as we look at the trends in demand for this talent. So this was actually an interesting one for us because, again, we've done this for 3 years now. You can see the data there from 2016 to today. And we weren't sure, especially in the U.S., how employers were going to sort of interpret the current administration's focus on immigration, because there was so much rhetoric out there. So we'll talk about those changes. There's definitely been quite a bit that have kept us on our toes here at Envoy. But it really did not, disparage employers, because this is such a critical talent pool. So 53% of employers expect their foreign national headcount to increase here in the U.S. And that is significantly up from 34% in 2016, and only slightly down from 2017, where it was 55%. And so one of the things that we start to hear from our, from employers is, yes, it is becoming more challenging here in the U.S. We'll talk about that from an immigration perspective. And so, we still put a lot of emphasis on our global, and obviously ERC, TRC, and others are super familiar with this. But, this demand hasn't waned either. So 59% of employers expect their demand for global or outbound immigration, so securing work authorization in countries outside of the U.S., to increase this year in 2018, and that's the same from last year. So no real change, but again, a pretty big number, almost 60% of employers that expect this demand or this function within their organizations to increase. But not too surprising, and again, this is really the crux and the focus of this webinar. A lot has changed over the last 12 months. And so when we asked employers, what are the biggest changes you've noticed under the current administration, not too surprisingly, 42% say increased foreign national anxiety, so really uncertainty. And I think as you look at all of these responses, and probably just even talking to your own workforce and your own populations that are international within your organizations, it's really just about this undercurrent of uncertainty. Foreign nationals refusing to start employment until their case is approved. Individual cases themselves becoming more difficult. We'll talk about increases in RFEs, positions taking longer to fill, increased audits, right, for immigration compliance. So these are all things that we've seen, or at least that employers are telling us that they've seen the biggest change over the last, or really since the inauguration of the current administration. And so one thing that I think we have to keep in mind that, for those of us who have been in the industry for well before this administration, but really for the last, decade plus, like Sarah, the U.S. immigration system has not just become a big challenge, right? It has been a challenge for employers for years. The H-1B lottery, of course, one of those that just wrapped, you know, last year was 199,000 applications for 85,000 spots. There just aren't enough options, and then we see that here when we ask what the impact of the current U.S. immigration system has been on organizations. You know, they've had to increase budgets, they've had to delay projects because they couldn't secure the talent, and then, you know, relocating work overseas, which is another one that, you know, we really do have to monitor and watch, you know, for those of us who care and you know, want, you know, not only the employers like all of you on the phone to find the best talent, but what that impact really is on our society and economy overall. And so what we also saw and wanted to validate through the surveys from our own customers is they started to change their policies. So inauguration happens, or election happens in November, inauguration at the, you know, right at the first of the year, and we saw an immediate change, actually an influx of really green cards. And so, so we asked, you know, how did you change your policies over the last 12 months, specifically around green cards? You can see there employers sponsoring more green cards, accelerating the timeline. We found that many of our customers said, yes, you know, we had a policy for a year after tenure, but we escalated that to 6 months or even immediately after hire date, so you see those changing. But overall, we always get this question, you know, what do policies look like? And this type of data, and if you go to our blog, and we're happy to share this report post the webinar, but if you, because there's tons and tons more of data in here, and this is the concluding slide on my part, but many of our customers ask, you know, what are the benchmarks? What should our green card policy be, especially here in the U.S.? What should the benefits from an immigration perspective be? So you can see there, we've tracked this over the last 3 years. Still a good majority of employers doing, you know, sponsoring green cards within that first year, you know, 61% really within a year of service, 35% immediately, and you can see sort of the differences across the board. But again, this was a big change over the last 12 months. And so as we look to, you know, why that's changing, we'll go into now just more detail, and Sarah will really dive into what has changed, what sort of rhetoric and has been more on the enforcement side versus policy side, and most importantly, you know, what should you as employers know, and what can you really communicate through your organization, especially to your foreign nationals that are in this age of uncertainty, and how do you bring some of that certainty and stability to them. So without further ado, I am super excited to pass the presentation over to Sarah. Again, just a phenomenal resource here at Envoy, years and years of immigration practice, and excited for you to share your knowledge with the group.
Thank you so much, Jamie, and thanks again, everyone, for attending. Without any hesitation, let's just dive right in to recent and proposed policy and regulatory changes and discuss in detail what employers are really experiencing in this space. And as Jamie said, talk about some tips and tricks that you can do to prepare and be proactive with communicating to your employees. Universally, okay, nationally, employers are reporting increased scrutiny, lengthier processing times, and less predictability with the immigration applications they're filing on behalf of their employees. This obviously means increased uncertainty for employers, for managers, for business units, as to whether they will be able to retain critical foreign national talent, as Jamie was talking about earlier, and of course, heightens anxiety and fear for the applicant going through the process. And so let's just take a look at this slide quickly, because I do think it breaks down the most impactful recent changes in really easy bite-sized pieces, and we're going to dig into these with a little more detail as we move forward. But one of the biggest things that we're seeing is overall increased scrutiny, and that's including upticks in requests for evidence, notices of intent to deny, actual denials, and a new and kind of particular focus on H-1B wages by the USCIS, when this has been kind of a realm for the DOL previously. We've seen a lot of talk and policy change around third-party placement evidentiary requirements, and there was also a computer programmer memo around this time last year that really questioned a specific occupation and whether it was still eligible for H-1B status, whether it was sophisticated enough to garner H-1B status. Additionally, we're seeing increased government processing time due to some new requirements, and I'm going to dig into some exact processing times that we're dealing with right now just to give you current real-time numbers later in the presentation. And as Jamie said, there's significant rhetoric that we're seeing directed towards employer compliance obligations and or the elimination of fraud in the employer-sponsored immigration space, and this includes extreme vetting of individual applicants as well. What are some examples of this? There's threats of on-site visits by DHS officials questioning specific H-1B and L petitions in particular, and I'm going to dig into that later. There's fraud investigations that we're seeing post-approval at the consular or the visa issuance stage. And this is something that I've heard reported from multiple employers, and it's really interesting. We're seeing that after approval, so an employer might submit an H-1B petition on behalf of an employee. You go through the entire CAP process, you're selected in the lottery, maybe you answer a very onerous RFE, you finally get that approval, you're feeling really good, and then your employee goes to the consulate abroad to obtain the visa stamp so that they can enter the U.S. and begin working for you, and you get a phone call from a fraud officer asking whether your signature on the original petition is legit, whether the cover letter that you submitted confirming that the job still exists was actually prepared by you and on your letterhead. And this is in addition to additional requests for evidence that are being directed at the applicant. And this is something new that we're seeing in this space over the last year or so, and I've heard reports from multiple employers that these phone calls are happening. And then, of course, there's a new proposed requirement to provide social media login information in tandem with visa applications for all applicants, not just those that are flagged as security risks. I'm going to go into that with more detail as well. And then finally, a big one that goes hand in hand with overall increased scrutiny is a lack of predictability and arbitrariness in decision-making. As anyone who's familiar with the space will say, this has always existed to some extent, but attorneys are reporting increased unpredictability, and this goes hand in hand again with the RFE issuance and just overall enhanced scrutiny. And another thing I'll identify in detail later is the elimination of deference to prior approvals when adjudicating extensions. Okay, so digging into the basis for a lot of this heightened scrutiny and new initiatives is the Buy American, Hire American Executive Order. I'm sure many of you are very familiar with this. It was effectuated on April 18th of 2017 when President Trump signed the order, which seeks to create higher wages and employment rates for U.S. workers and to protect the economic interests of U.S. workers by rigorously enforcing and administrating immigration laws. It also directs DHS in coordination with other agencies to advance policies to help ensure H-1B visas are rewarded to only the most skilled and highest paid beneficiaries. And so a lot of the initiatives, policy changes, regulatory changes, proposed legislation is a result of this order and agency interpretation of this order. Okay. Okay, sorry about that, a little delay in moving the slides along. So going through some of the kind of vetting that we've seen and looking at recent changes that you're currently responding to, in Q4 of 2017, USCIS began expanding in-person interviews for certain immigration benefit applicants. Specifically, when applying for adjustment of status interviews for employment-based green cards, they're now requiring an in-person interview. Historically, USCIS always had the discretion to request that interview, but in practice it really didn't happen. It happened regularly for family-based applications, but for employer-sponsored petitions it was extremely rare to be called in for an official interview. And this requirement is a really good example of heightened security measures and vetting. The practical pointer here is that interviews add another step to the green card process, which any employer involved in it can tell you is pretty interminable and fairly onerous. And it also expends government resources, which adds to delays. And now you have officers who have to be dedicated to giving these interviews, conducting these interviews. And so just to give you an idea of the kind of real-time example of delay related to this, as of this morning, adjustment of status applications pending with the Texas Service Center. I don't know why I'm picking on Texas, but I am. They're expected to process within 9 to 11.5 months. These are employment-based adjustment of status applications. Only cases filed prior to May 3rd of 2017, so nearly a year ago, are ripe for case inquiry. So that means that unless you have an application that was filed with a receipt date prior to May 3rd of 2017, you can't call in to the USCIS or submit a case status request. Additionally, adjustment of status applications are not eligible for premium processing and therefore cannot be expedited. And this is a pretty difficult one because it is that kind of last hurdle before the green card is issued. But what can employers do? Really the best things here are to communicate and to plan ahead, knowing that the process is going to take even longer than anticipated and can't be compared to employees who went through the process even a year ago. Managing those expectations is really critical. Continuing the vetting conversation, let's talk about another proposed instance of heightened security measures in the form of extreme vetting. I mentioned this at the outset, but on March 30th, the Department of State submitted a proposed rule for public notice and comment that would require all U.S. visa applicants to submit social media usernames, email addresses, and phone number histories in the context of the visa application itself. Previously, this information was only requested from applicants who are identified as requiring additional scrutiny or who might be a security risk, so typically including applicants who may have traveled to areas that were controlled by terrorist organizations, for example. Reports estimated that approximately 65,000 people last year fell into that category, into the kind of heightened security risk category. Conversely, if the proposed rule is enacted as written, nearly 15 million visa applicants will be affected on an annual basis. So that's a really big number. And one of the reasons for this is because the rule proposes to revise the DS-160 and the DS-260, the application forms for the visa itself, to require this information. So every single visa applicant in a calendar year would be required to complete that application requesting this additional data. So fairly onerous. Switching gears just a little bit, but kind of staying in the vein of policy updates that are either pending or have already been implemented, I want to turn to USCIS approval policy. So this is a recent policy update that's really impacting employers on a daily basis because it's rescinding or did rescind existing policy related to approvals in the extension context. On October 23rd of 2017, USCIS released a policy memo instructing officers to apply the same level of scrutiny to both initial petitions and extension requests. The updated guidance contradicts and replaces prior policy, which instructed adjudicators to give deference to prior approvals when reviewing extension requests, absent a material change or evidence of material error or fraud related to the prior determination. So what does that mean in practice? Well, that means in practice that prior to October 23rd, 2017, most folks who were submitting an extension petition had a fair idea of a positive outcome. Now, every petition is being reviewed with the same level of scrutiny as an initial petition. This memo is part of the Buy American, Hire American initiatives, and in practice is likely contributing to the increased RFE rate that we're going to discuss later in this presentation. Okay. Before we turn to the RFE topic in more detail, let's chat a bit about immigration enforcement under the current administration. To put a number on it, in the first 100 days following the inauguration, immigration-related arrests climbed nearly 40% over the previous year. This is interesting for multiple reasons, not the least of which is because the Obama administration's enforcement efforts highly prioritized convicted criminals and threats to national security and public safety, and arrest and deportation numbers steadily increased throughout his presidency. Now, while these recent enforcement trends are perhaps less concerning to the average corporation or HR department that's engaging in good faith compliance with hiring and other immigration practices, the impact here is that criminal immigration requires a lot of cooperation among government agencies at both the state and federal level. And so never before have we seen this level of cooperation or access to shared data. So all of these agencies across all of these different states and at the federal level all are kind of having shared databases and data sharing, and something that we have not seen in the past. So that's fairly interesting. Moving on in the enforcement topic, another area focuses on employers who sponsor foreign nationals for work authorization, and this is particularly seen in the H&L categories. And what I'm talking about is the USCIS Fraud Detection and National Security Directorate. Now, the FDNS has been in place since July of 2009, and many employers are going to report that they received site visits back to that date. It's definitely not a new agency. However, in April of 2017, the USCIS announced increased measures to deter H-1B fraud and abuse and confirmed that the agency would take a more targeted approach when making site visits to H-1B employers specifically. And the USCIS announced exactly who they're targeting. It's 3 different categories. It's cases where the USCIS cannot validate the employer's basic business information through commercially available data. It's H-1B dependent employers. And it's employers petitioning for H-1B workers who will be placed at third-party work sites. Notably, the stated reason for the site visits is not to target non-immigrant employees, but rather to identify employers who are abusing the system. Another interesting note is that in general, high-volume petitioners are likely to see more audits and on-site visits. So even if you're not in one of those targeted categories, because these site visits tend to be one-to-one, meaning that the officers are arriving to verify a specific petition, if you have a higher volume of petitions filed, then as a result, you're more likely to see increased audits and visits. So what can you as an employer do to prepare? Simple. Have a plan. Have a reaction protocol. Practice. The best thing that an employer can do is to be ready. Train receptionists and staff who are likely to receive the initial unannounced visitor. Who should they notify internally? What is the agreed upon party line to the officer as you ask him to wait? Who will call your immigration counsel? Should your internal legal team be notified? Who will be trained as backup in case key personnel are out the day of the visit? Answering these questions, partnering with your internal or immigration counsel to establish a plan, and practicing will prepare you as much as possible for an unannounced visit. Further preparations can include audits of your immigration files to ensure that you're aware as a company of where your risks are, what shape your files are in, and what areas need improvement and potentially kind of policy reform going forward. You can perform those audits as a company, or you could also request immigration counsel support. Okay, now let's discuss some of the fallout from the Buy American, Hire American directive and related heightened scrutiny. I'm turning to everyone's favorite topic, RFEs. Requests for evidence are requests from the government for new or additional information in response to an employer's filing of an immigration petition on behalf of an employee. Okay, and I think many employers were lucky enough to have never seen one of these until the last year or so, but now we're seeing a massive, massive uptick. Indeed, attorneys and employers have seen a marked increase in RFEs for H-1B cases in particular across all sectors. And this trend has actually been supported by data disclosed through a Freedom of Information Act request that was submitted by Reuters and reported in a September 2017 article. So it's really excellent to have kind of the hard numbers here. So according to this data, the USCIS issued 85,000 requests for evidence between January 1st and August 31st of 2017. Notably, these numbers were published before the October 2017 memo that abolished deference to prior approvals. So I think we can expect that that number is going to increase even further given the lack of deference. So what does 85,000 RFEs during that time period mean? Well, it's a 45% increase over the same period in 2016, and the highest in 8 years. The article mentions several pertinent examples that underscore the impact of this heightened scrutiny, including the experience of one company who hadn't had but one RFE since 2015, who received 6 in a single day. But where is this massive uptick coming from? Practitioners are tying the increase to various policy changes that have been brewing since January of 2017, and many of which we've either already discussed today or will be continuing to discuss in the remainder of this presentation. But tapping some of them out, the memo for the computer programmer questioning whether it's sophisticated enough to qualify for the H-1B visa, the level 1 wage RFEs that I'm going to expand upon in just a moment, and really just in general, the increase is a likely outgrowth of the Buy American, Hire American order and general directives from the current administration to protect U.S. jobs and increase scrutiny in the adjudication of employer-sponsored immigration petitions. And this administration has particular emphasis on the H-1B. Now, importantly, practitioners are reporting that these increases are occurring without regard to geographic location, the national origin of the applicant, or even without regard to company size. That said, employers who more regularly hire entry-level workers may be feeling the impact more acutely. Why is this? This is because while specific employers are not being targeted, certain positions are, and more specifically, certain wage levels are. Jobs that pay entry-level wages are being closely scrutinized by USCIS and are more likely to be subject to RFEs. This is huge during last year's CAP adjudication series. It's an entirely new type of RFE, and it's often called the Level 1 Wage RFE. And it's being issued for entry-level jobs across all sectors and professions. So it's not just touching the tech industry or the computer programmers who are impacted by that memo. It's really looking at all entry-level roles. So this could include financial analysts, accountants, engineers, physicians, jobs and occupations that have always kind of traditionally been specialty occupations. So this is a big change. Okay. So how do you as an employer prepare? Companies really should anticipate longer timelines and additional costs to be associated with responding to these RFEs and delays, particularly if it's the first H-1B for someone and they're outside the country. The RFE is going to delay the issuance of that ultimate visa stamp and the approval that allows them to enter the country and begin working. Employers should factor in several months for the RFE process. The USCIS generally allows up to 12 weeks or 84 days for employers to respond to an RFE. Once responses are submitted, there really is no deadline for USCIS to respond, but we typically see that the agency finalizes adjudication within 2 to 4 months. So this additional 2 to 4 months is on top of the processing times that have already been incurred to even get to that RFE point. Okay. Now I'd like to spend a few minutes running through some of the proposed legislation, rules, and regulations that have a particular emphasis on the H-1B category. While there is a bill in Congress, and that's what this slide relates to, there is a bill in Congress that could make it harder for H-1B dependent employers to place H-1B employees at third-party work sites. There's also relevant recent policy guidance that actually changes the evidentiary standard for all H-1B employers who are utilizing off-site placement for their H-1B workers. So on February 22nd of this year, USCIS published a policy memo in line with the Buy American, Hire American directives, making it very clear that USCIS can request detailed documentation to ensure that a legitimate employer-employee relationship is maintained throughout the validity period of the H-1B visa and while the employee is working at a third-party work site. In publishing this policy, the USCIS has been very clear that it is attempting to clarify existing regulatory requirements relating to H-1B petitions filed for workers who will be placed off-site. The memo dictates that employers must provide contracts and itineraries for employees who will work at a third-party location. In practice, these items were often only provided to the USCIS in response to a request for evidence, and now they're basically required as initial evidence with the premier filing, or the case in chief, as it were. The new policy clarifies that petitioners who employ H-1B beneficiaries that are placed off-site must demonstrate that they have specific and non-speculative qualifying assignments in a specialty occupation for the beneficiary for the entire time requested on the petition. This is actually really important information, and it is quite onerous for a lot of employers to provide. If you think of, say, a lawyer, like if you're applying for an H-1B petition for Sarah Maxwell for 3 years to work at, her law firm, and you have to dictate to the USCIS every single piece of work or project that she's going to be working on for the entire 3-year period with some level of detail. That's extremely onerous and potentially impossible, right? You know the work is coming in, but you may or may not know exactly where the project will be located or who it will be for or how much the statement of work will be valued. So this is a really, really high level of scrutiny and a high level of evidentiary requirement that is being levied at employers who do have employees working off-site while in H-1B status. The results of not being able to submit enough documentation to kind of justify those non-speculative assignments means that the USCIS is truncating approvals. So even where a 3-year approval might be available in theory, we're seeing that the USCIS is truncating that for the amount of time that you're able to substantiate the work. Oftentimes, it's rolled out to a 1-year approval. Another kind of interesting upcoming change is that the H-1B term of specialty occupation may change. So this came out in December of 2017, and we expect a proposal in October of this year, but this one's really fun. It's really interesting, and I hope you feel my sarcasm, because it has the potential to redefine the entire H-1B category. As all current requirements in the entire kind of evidentiary process for the H-1B is based on the fact that specialty occupation is defined as requiring a bachelor's degree or its equivalent in a specific specialty as the minimum for entry into the specific occupation. So any altering of that definition could fundamentally change the H-1B category itself and the kind of eligibility determination of each individual who would be going through the H-1B process. We'll have to wait and see. The proposal is not expected until later this year, but we can expect some potential fine-tuning there to be pretty interesting for all of us. H-1B pre-registration. This is not actually brand new. There was a 2011 Obama-era initiative to create an electronic pre-registration process for CAP season for the lottery. Details were expected to be published in February and potentially rolled out for this year's CAP season, but given that CAP closed just a few days ago or early last week, I can't even remember anymore, all the days run together. In any case, it's not in effect for this year, but we can potentially see something about that later this year and have that in place for CAP next year. So again, have to wait and see on that one. It's unclear exactly what's going to happen there. H-4 program changes. There's been rhetoric around this, I think, since the inauguration, and then in December of 2017, DHS did give notice that it's reviewing the H-4 EAD rule in light of the Buy American, Hire American executive order. And just as a quick recap, the H-4 EAD rule provides work authorization to certain H-4 spouses of H-1B applicants who are in a certain part of the green card process. And so it has afforded work authorization to a class of people who historically have not been able to work and were reliant on their H-1B spouse and that single income. The impact is that it could affect more than 100,000 work authorized individuals and their families. According to a March 1st status report from the DHS, they do plan to propose the regulation in June of this year. They most recently reported the status update March 1, and they're, I believe, required to give updates. I think it's every 30 days. So we will hopefully see something by June of 2018. But they're reevaluating the rule, and they've announced that significant revisions to the draft proposal are necessary. So hopefully we'll see something on that very soon. TN visa. So there's been a lot of conversations because of the negotiation going on with NAFTA that the TN visa is going to be scrapped. The fact right now is that all 3 countries are currently in between the 7th. They've just concluded the 7th round of negotiations and are ramping up for the 8th round of negotiations. So it's not going anywhere right yet, but it is something that I'm sure any employer who utilizes the TN visa should be paying attention to, and we'll all be reporting on this as things change. One thing to think about is that the TN profession and the occupation categories are changing. So this is something that can be modified, without the entire act being removed. And that's that the USCIS is modifying which types of employees can apply or which types of experience will be appropriate for a TN professional category. And this is impacting new TN applications, extensions, and then of course international travel, especially for Canadian nationals who travel without a visa and may be presenting their TN application, every time they cross the border, depending on what questions are asked of them. So what does this mean for employers who utilize the TN visa? TN categories are receiving higher levels of scrutiny, and as evidenced by the economist category, various occupations are changing, or at least are in the process of potentially changing. We recommend that employers review their TN workforce with their attorney to determine whether there are any continuing eligibility concerns for specific individuals and whether a potential switch to a new visa category may be required if available. We're getting close to kind of the end of time, and I do want to leave time for questions, so I'm going to kind of speed through the next couple of categories, but these do have impacts on employers. So I'm sure everyone's very familiar with DACA, and it is in the news, so I'm just going to give just a quick status update here. Due to federal court orders, there's a variety of court orders going on at present. I think New York and California actually both have orders out. The USCIS has resumed accepting requests to renew a grant of deferred action under DACA. USCIS is not accepting requests from individuals who have never before been granted deferred action under DACA, so it's not working for an initial request, but the gates are still open, and until further notice or unless otherwise, provided due to subsequent orders or subsequent litigation, DACA policy is operative and renewal applications are being accepted. Okay, and just to give you an idea of kind of the number of potentially impacted individuals, if you combine DACA and then TPS, and for those of you who may not know what TPS is called Temporary Protected Status, and it's a status that the Secretary of Homeland Security can designate for an entire foreign country due to conditions in that country that could temporarily prevent nationals from returning safely. And so usually the basis for granting TPS is an ongoing armed conflict such as a civil war in that country, an environmental disaster, maybe an earthquake or a hurricane, or other extraordinary and temporary conditions. And the benefit of TPS that's relevant to our discussion today is that you can obtain an employment authorization document for the validity of your TPS period. And so this chart shows the number of individuals legally working in the United States under these categories, under these TPS categories for the listed countries, and then of course with DACA. And so if DACA or TPS is rescinded and terminates according to some of these scheduled dates here, the estimated loss of work authorization is nearly 1.2 million. And so that is a lot of affected employers, not to mention individuals and families. Another proposed rule for revision is optional practical training. So a lot of employers are likely familiar with this one, but it generally occurs after graduation from a U.S. institution. Foreign nationals who are attending that institution on an F-1 visa are eligible for 12 months of optional practical training, meaning that they can work lawfully within the United States. There is also what's called a STEM extension for graduates of U.S. universities with STEM degrees, which with an Obama-era extension expanded the total period of optional practical training for up to 3 years for these eligible graduates. So what do we know so far about potential restrictions to OPT STEM? We know that national security strategy supports restriction on foreign STEM students from designated countries to ensure that the intellectual property that they have access to is not transferred to competitors. So that's one area of focus in revising the regulation or the rule. Additionally, DHS regulatory agenda supports reforms that will improve the protection of U.S. workers. So that is likely that reforms will include eliminating the 24-month STEM extension, which was expanded from 17 months during the Obama administration, as there are reports or complaints that these STEM extension graduates are taking jobs from U.S. workers. So the rhetoric and the thought there is that that 24-month extension may be eradicated. So planning for TPS, for DACA, for H4, for OPT employees' possible inability to continue to work. Again, all of these are proposed changes, so nothing has been determined yet. But the best thing that you can do is try and prepare and plan. So make a list of potentially impacted employees and have that list evaluated. Importantly, you should have this evaluated not just from an immigration perspective and a work authorization perspective, but also from an employment discrimination perspective. This is a really careful area that needs to be considered to ensure that you're not discriminating against these employees in an inappropriate way. And so kind of the way that you approach them needs to be delicate and should be vetted carefully. Consider using the H-1B lottery in the upcoming year if that's available to you. Plan exit strategies in the event that an H-1B lottery or other visa categories are not an option for your employee. Perhaps you could transfer them if you're a multinational organization. Perhaps you could transfer them to locations abroad. And again, just from an emotional and an aesthetic perspective, prepare for concerned coworkers and be ready to address the politics. That's a big one. The communication here is key, and whatever your immigration counsel can do to help you with that, we know they'd love to. And finally, just a few closing thoughts and recommendations before we open it up to questions. I think one of the biggest takeaways is that we urge you not to interact with immigration offices or officials without an immigration attorney present or without being first prepared by an attorney for your appointment. You can always ask for more time to consult with counsel. You always have that right. And again, you should be prepared as much as possible for any on-site or unexpected visits, so having those plans in place. Given the long wait times and delays in obtaining approvals for immigration benefits, you should ask your employees to notify you before they engage in international travel. You'll want to plan whether that travel impacts a potential renewal or amendment that may need to take place, or whether they may need a new visa stamp while they're abroad that could be subject to long delays or some of the fraud scrutiny or anti-fraud scrutiny that we're seeing at the consular level. And then, of course, just allowing for more case preparation time than normal, really focusing on the fact that RFEs could delay case adjudication and that premium processing has been eliminated in the past and it may be eliminated again in the future, and that elimination doesn't just relate to the instant petitions, but it also causes backlogs and long time delay as a result. So I know I've been a bearer of a lot of really exciting and fun news, but thank you so much for listening, and I'm going to turn it over to questions.
Awesome, thank you. Thank you, Sarah. So as Sarah mentioned, we did leave a little bit of time. There was a ton that we just went over. Now, hopefully, everyone on the line can hear my enthusiasm for Sarah and her wealth of knowledge. And there is a ton of changes happened. So please look in the right-hand corner. There's a Q&A section, and that's actually where you'll post your question. A few of you have been posting up to this point, so I'm just going to read through a few of these. These are most definitely directed towards Sarah, and it's really, a couple of them, and I'll give the caveat that I'm sure Sarah will reinforce, but, obviously this is immigration and this is law, so every situation is unique, every individual is unique, and so there's tons and tons that go into it, but I think, Sarah, there's some good questions that you can give sort of a more cursory overview. One of them, you began talking about the consulate and some of the denials that we're seeing at the consulate. If an employee's visa is denied or revoked during a consulate visit, how long can you continue to pay them from the U.S. if they're not doing work? Is there anything that employers should think about or plan for if that is the case?
So if their visa is denied at the consulate and they're not in the United States, so it sounds like with this question they're potentially working for you remotely during this period, and you're wondering how long they can remain on U.S. payroll. From a U.S. immigration perspective, indefinitely, because they're outside the United States, right? But it is a question of tax and permanent establishment and potentially employment law and other concerns. So you would want to seek employment and tax counsel if you were going to continue to have that individual work remotely. I know that's often a tactic that employers use perhaps when someone doesn't have a ton of time left in H-1B status, but their green card is still pending. They'll often send them back to their home country and allow them to work for a little bit while that green card is still processing. So this isn't an unheard of tactic. It's just one that does have implications outside of just immigration law.
Okay. Great. And then there's a couple questions actually on the TN. I know you talked about the possibility of NAFTA being canceled, and so what does that happen to the TN? So actually two very similar questions. One, would it be recommended to hurry up and apply to those TN visas now before anticipated changes? And definitely related, will there be an impact on those visas that perhaps they're applied for and then some of these changes happen? Is there any sort of direction or recommendation on those types of applications?
Sure. I mean, I think what's really interesting about this is we don't really have a great idea of how it's going to be rolled out. If I can kind of compare it to Brexit, even Brexit is taking kind of years to figure out exactly how categories of people are going to be treated. And I have to assume that in the NAFTA space, even if they immediately abolish the TN category, there still has to be the people who already have TN status. Are they immediately stripped of status? Those questions haven't been answered, so I don't have a good basis for you now. I think the general kind of global response to that would be that when a program is abolished, there's usually a phase-out period, and individuals are typically kind of put on notice that they need to change categories and given some time to do so, but I certainly can't guarantee that that would happen in this case. So I would say that, I'm a fairly cautious, risk-averse person. My recommendation would be to review any employees who are in TN status and see if there's another option, and particularly a quick jumping-off option. Like maybe they're already eligible for an L1, or you were already planning on sponsoring them for a green card, or they're married to a U.S. citizen, or have some other quick jump-off benefit. Such that you wouldn't even have to go through the H-1B lottery for them. I would definitely start the analysis for those employees.
Okay, that makes sense. That answered the other question they had around the TN. I know the answer to this, but I know a lot of people have questions on it, and it's the classic law school or MBA school answer. It depends, but do we have any ideas of how long it's taking to get responses back from the USCIS after RFE responses are submitted? Again, that's all over the board, but your insight on it will be helpful for people.
It is all over the board. I say generally 2 to 4 months, but Actually, the USCIS just last month rolled out a new case processing time system, and it hasn't rolled it out to non-immigrant categories, so it's unclear how those will be impacted, but I'm interested to see because it's actually a real-time case processing map. So keep an eye on that, just as a complete aside, because I discovered that the other week and thought it was fascinating. But as it relates to RFEs specifically, I would say anywhere from 2 to 4 months, with the caveat that there are always outliers. I've had applications for my clients that sat on a desk and USCIS admitted that, oh, it fell into a drawer. I'm sorry, we found it. So there are always those outliers, but generally 2 to 4 months from your submission of the RFE response.
Okay, great. There are tons of questions, so I'm going to try to get through as many of these as possible. One, just as a broad sweeping, yes, you will get a copy of the presentation and of the slides, so there's quite a few on that. And then there's a few quickies. So are soft copy or digital files for public access files acceptable?
Ah, that's a great question. The short answer is arguably yes. Nothing has been officially published, but the Department of Labor, in a meeting with, I think it was AILA officials, announced that yes, a digital copy or an electronic copy of the signed and posted LCA, the posted LCA, would be appropriate. So yes, take that to mean that a full digital copy of your public access file is supportable.
Which is super helpful because I hear many stories of the cabinets and closet full of those documents. So exactly. That'll be helpful. One, lining right in the cloud that's a little bit more positive. So a question on, so you talked a lot about audits, and you talked a lot about sort of your rights to what you can or should talk to different departments and officers about. So here's a question around: am I required to let ICE in to inspect I-9s on an unannounced visit, or only with a warrant? Do they need to give me, some sort of, notification before they come? You mentioned having a plan for this. Is there sort of any sort of broad sweeping advice that you would give on that?
Sure. So when ICE appears for an I-9 audit, they should be appearing with a notice of inspection, which details what they're asking for and should give you as an employer 72 hours to respond. In practice, I've actually found that ICE and other officials are pretty reasonable, and oftentimes if you can get your attorney involved, they can even request additional time. I've gotten weeks before. I've also been able to truncate requests, so if they outlined, 15 bullet points that they wanted to see, bullet points of documentation that they wanted to see, we've been able to go back to them and negotiate that and say, well, here's what we have readily available. This is what we'll agree to give right away. So I would say the right approach is to be polite and accepting of the officer's summons and understand what they're there for, what they want, but then excuse yourself to talk to your attorney and figure out next steps.
Great. And then there's actually a couple questions on green cards. I think we can sneak in a few of your questions all in one. So just broadly, are there any other green card challenges to consider besides a potential in-person interview? And related, someone asked, should we assume that all green cards will have interviews, or is that randomly selected? Is there any indication on insight into that?
Sure. So the rule is that all employment-based green cards can be selected for interview. So I think the assumption is that the correct assumption would be that you're going to be selected. But again, that's because I'm a cautious person and I like to manage expectations as clearly as possible. So yes, anyone who has submitted an employment-based adjustment of status petition could be selected for an interview.
Okay. Wonderful. We did not get to all of the questions. There are actually quite a few left, but we are coming up on our time. So I wanted to give Allison and ERC the baton back, but just thank you to everyone. We're honored to be a part of this webinar, and thank you so much to Sarah for bestowing all your knowledge on us. Appreciate it.
Yes, thank you, Jamie and Sarah, for sharing your insights with us today. A special thank you to Envoy Global for presenting this webinar, and a very special thank you to TRC Global Mobility for sponsoring this webinar. You all have been a wonderful audience. I hope you have enjoyed today's webinar program. Just a quick reminder, keep an eye on our Worldwide ERC website. We are constantly adding new events. And of course, watch your emails for a copy of today's presentation. It will come to you from messenger@webex.com. Thank you again. Have a great afternoon, and you may all now disconnect.